I think that actually cuts against you because you suggest that the government or that Congress channeled the government's authority to the initial stage. And I'm wondering how you can say that given the history. It seems as though the history of the statute is pretty clear that Congress only amended it to allow for later intervention because it was concerned that the government didn't have an opportunity to intervene after the initial period. So this is sort of in line with my colleagues suggesting that they wanted the government to be able to come back in and take over the case if things had changed or the circumstances were such. And it was also clear from the history that Congress was concerned about the relator having no role in the suit if the government came back later. So how is that consistent with your theory that the government has sort of an all or nothing choice to be made at the beginning of this and it can't intervene later and then act to dismiss the suit or do whatever else?
Sure. Well, just to be clear, it is not an all or nothing choice anymore, and our theory is perfectly consistent with what Congress did in 1986. Before 1986, the government couldn't intervene in the case after the fact. After 1986, the government can intervene. Now, it can't intervene and proceed with the action. Congress said only intervene in C3, and it said they can do it with good cause. And they said, importantly, they can do it without affecting, without limiting the status and rights of the relator.
I'm sorry, so what's the purpose of the intervention then if they can't then take over the action and proceed?
Oh, the purpose is very important. It gives the government a chance to litigate as a full party. Now, what they can't do is invoke the specific limitations, and that's how C1 describes it in paragraph 2. Paragraph 2 sets out special limitations on the relator's rights where the government initially proceeds with the action. And this is very clear from the structure of the Act. The Congress put the government to an initial choice under subsection B. And it said you can either proceed with the action or you can decline, in which case the relator has the right to conduct the action. And then it marched through the different rights to the parties to the action in subsection C.